All right, everyone. Going live again with no intro. Once again, doing a little bit of experimentation here. Okay, we're talking about the latest updates in one of the many lawsuits against David Miscavige, against Scientology. There was an ex parte emergency hearing that was scheduled this morning. Jacob Harkey was present in the courtroom for what was supposed to be on the schedule. I'm going to bring on Jacob, and I'm going to bring on my lawyer friend, Zach, to discuss what is going on. So welcome, Jacob, and welcome, Zach.
Hello. Thanks for having me. And nice to meet you, Zach. I've seen lots of your updates with Aaron before that have been very helpful for understanding what's going on in these legal cases. So thanks for all you do.
Well, thanks, and I appreciate you being in the courtroom today. California was a bit of a stretch for me to be able to go on an emergency notice, so I appreciate you covering for me out there.
Totally.
Okay, so first we're going to discuss the Jane Doe versus David Miscavige and Scientology lawsuit, and then we're going to discuss issues relating to Francois Coster and Law Poubelle and everything that's going on there. Okay, so try to bring us up to speed. I don't want to assume that the audience already knows what we're talking about, but try to bring us up to speed on what happened this morning and what the context is.
Sure. So as far as context, this, like you said, is a hearing in the Jane Doe v. Religious Technology Center et al. Lawsuit. And as a quick summary of what that lawsuit is all about, Jane Doe, the plaintiff in the case, is an ex-Scientologist and ex-Sea Org member who was recruited into the Sea organization as a minor. She was SA'd by her Sea Org recruiter and then forced into a marriage with him, and that man is Gavin Potter. So she's suing Church of Scientology International, Religious Technology Center, David Miscavige, and Gavin Potter. And Scientology, in fall of last year, did what they usually do in lawsuits that are filed against Scientology, where they file a motion to compel arbitration, and they pull out a contract that the Scientologists signed while they were a member of the church, stating that they would never sue the church and that they would take all grievances into internal religious arbitration. So after filing that motion, Jane Doe's legal team filed a motion for leave to be able to conduct limited discovery specifically related to the arbitration issue and the arbitration contract and the circumstances that led to her signing that contract. Well, in December of 2023, just a few months ago, the judge did rule in Jane Doe's favor that her team would be able to conduct limited discovery pertaining to that arbitration agreement. So that motion for that we still have yet to determine. Sorry, I'm getting jumbled over my words. We still have yet to hear from the judge about what the final ruling is going to be about whether arbitration is going to be compelled. But today's ex parte hearing or emergency hearing had to do with a motion that was just filed by Jane Doe's legal team last week, as I understand, about potentially bringing in a new key witness with very intimate knowledge of the circumstances that led to Jane Doe signing that arbitration agreement. And we showed up at the courthouse. I was here before 8:30, which is when the hearing was scheduled for, as I understood it. I did not see the case posted on the calendar outside of Judge Broadbelt's courtroom. But we went in there when we opened the doors, and Scientology's attorneys were there. Bill Foreman was there for Church of Scientology International, and Peggy Dayton was there for Church of Scientology International. And then there was also a guy who I believe is with OSA that's been there at just about every hearing that I've been to, and he sits with the defense. I don't know what the guy's name is, but he was there too. Before the judge even came out of his chambers, when it was just the clerks taking roll of which attorneys were there, he indicated that I think there were a couple of ex parte hearings that were not on the calendar, but that were going to be discussed before the main agenda was reached for today. And he mentioned that for the Jane Doe v. Religious Technology Center et al., the motion was denied and that there would be no hearing. And so we cleared out of the courtroom before anything else eventful happened pertaining to the case. We didn't even see the judge. But that's a summary of kind of what happened there.
So my understanding is that the ex parte motion was denied because basically there wasn't enough information. This was the argument Scientology's attorneys made. Wasn't enough information to really explain what the person was going to testify to that would explain why it was so urgent and that it had to be admitted at this later date. So given that's the case, Zach, what do you speculate might happen after this point? What are the options?
So, of course, the One of the things that will likely happen is, one, the judge will reduce the order to writing. Oral orders, oral decisions are common, but they don't sit in the record. So it has to be reduced to writing, or you would have to have a court reporter transcribe the judge's ruling. Obviously, no court reporter present, and there's generally not court reporters present for just a run-of-the-mill cattle call docket. That's the exception, not the rule. So the judge will reduce this to writing, and in that order, the judge should put the reasons for the denial. And assuming the reason for the denial is insufficient information is pled in the application, then that certainly gives Jane Doe's attorneys every opportunity to dig out of their back pocket all of the evidence, not just the evidence from this secret star witness, but all of the evidence that has been obtained through discovery. And Scientology's attorney is going to freak out and say, "Oh, none of this should all be sealed. None of this should be on the record." And the judge is going to say, "You argued that they didn't have enough information. Here's the information, and we can't redact it after the fact." So it's a double-edged sword. It's, you play it. It's a balancing act. I need to put enough information in there for the judge to make heads or tails of the issue, but not so much as to give away my litigation strategy. And and in this case, they came in a little bit too conservative. But assuming the judge's order says what I anticipate it will, that takes the strings off. And so any evidentiary objections, any discovery objections that Scientology may have, and all the things that they're fighting like hell to keep out are going to come in. At least not necessarily to the jury if we get to that point, but at least it'll be a part of the court record going forward for this case. And ultimately, even if the judge denies, even after all the evidence comes in for the purposes of the evidentiary hearing, even if the judge denies it, this is allowing Jane Doe's attorneys to build the record for appeal. Because forcing something into binding arbitration is appealable, because it's appealable on the grounds that the judge misinterpreted the law, or the judge correctly applied the law, but the law is wrong and is depriving me of my due process access to the courts.
That makes sense. I have another question on this. So, under the Biden administration, a law was enacted preventing child sex abuse cases from being pushed into arbitration. And my understanding is that the language of the law was a little ambiguous on whether it meant that this applied only to crimes committed after the law was enacted, or only to lawsuits that were brought after the law was enacted, even if the crime was committed before the law was enacted. There is a California appellate decision that really might only be about two or 3 months old that weighs in on this and says this law applies to lawsuits brought after the law was enacted, even if the crime was committed before the law was enacted. The law of the land is on Jane Doe's side. Would it be a mistake to keep pushing this request for additional evidence, witnesses, facts, when the law of the land is already on her side?
So the answer is maybe, unfortunately, in my opinion, because if the trial judge says, I interpret the California Court of Appeals case law differently and forces it into arbitration, they're stuck with that decision. They go ahead and they continue to build the record. They put their evidence on the record so that if they win, they don't have to appeal. But lawyers approach a case from the perspective of, I always have to assume a mistake is going to be made and I'm going to have to appeal. And I want to make sure that I build the record as entirely as I possibly can to protect me and to protect my case and to protect my facts going up on appeal. Now, as an attorney, we love ambiguous and gray, unclear legislation because it keeps us employed. But I think it's really, I think, a reasonable interpretation. A lot of courts, even at the federal level, will look and say, what was the intent of the legislative body? What was the intent of Congress in passing this legislation, and the intent of the executive in signing this legislation? And there's a very strong argument to make, and Jane Doe's lawyers will, if they haven't already, be making this argument. And that is, the purpose of this legislation is to extend protections to victims of childhood SA. And if we limit their recourse only to criminal actions, we're undermining the legislative intent. The legislature intended for this to be as broad as it possibly could to provide all the protections possible to victims of childhood FA. And by narrowing it to criminal matters only, it defeats the purpose of the legislature. So there's a great argument to make that this is that type of law that needs to be super broad.
Super interesting. Okay, good. So as of right now, it does look like the next hearing in this Jane Doe versus David Miscavige, Gavin Potter, RTC, CSI, and Bridge lawsuit is April 16th. It remains to be seen whether Jane Doe's team will request, what's the motion called? Motion to reconsider?
Yeah.
And if they do request it, whether there'll be some hearing before April 16th or not. So I guess we'll just have to wait and see. Zach, maybe you can stay on with us as long as you can while we move on to the next issue, and then you can jump off whenever you need to.
Sure.
Okay, it turns out Francois Coster, the owner of La Poubelle, the restaurant where Danny Masterson drugged at least one of his victims, Francois Coster, the owner of La Poubelle, someone who has stood by Danny Masterson's side, supported him publicly, shamed the Jane Does, harassed them in the courthouse. It turns out La Poubelle's got some problems of their own, some new problems, some old problems that are new problems that we're just learning about. What have you discovered, Jacob?
So over the last couple of weeks, since I've been coming to the courthouse regularly, I've come to realize that the computers at the courthouse can be used to access all documents that are imaged from any cases that have come through the Los Angeles Superior Court free of charge, because you can do the same thing on a computer at home. You just got to pay more money for it. What I've found are a couple of interesting cases that I found from searching Francois Coster's name and also from searching La Poubelle. And one of them that's particularly interesting to me is a case called Browder v. Haynes. So it's Robert Browder, plaintiff, v. Ryan Joseph Haynes, La Poubelle Incorporated, as well as a couple of other businesses that are in the same general area as La Poubelle. Apparently, from the limited skimming that I've been able to do of some of the documents from the case, a man was beaten up right outside of La Poubelle, and part of the reason that this is particularly interesting to me now is because Francois Coster has filed restraining orders against William Good, Streets LA, and DOA, or Scott Hochstetter. And in the petition that she's filed for obtaining a restraining order, she's mentioned that she has been the owner of La Poubelle for decades without incident. Well, based on what appears in the lawsuit, it sounds like, okay, there's at least one person who has sued over a violent assault that they experienced right out front, and then also included in this lawsuit is a declaration from a manager at Birds, which is another bar down the street, who mentions that he has witnessed violent encounters outside of La Poubelle many times. Now, I'm at the stage that I'm at right now. I'm still kind of continuing to dig through stuff and trying to continue to learn more. But because DOA and Streets have upcoming hearings related to the restraining order, I would like for them to be able to get all of the information that they can and get all of the information that we can get out there about the history of violence in front of La Poubelle, just to show that what Francois Coster has alleged, that she has owned La Poubelle for decades without incident, is not true. There is a history that is documented in this lawsuit of violence right outside La Poubelle. I hope that makes sense so far.
Yeah. Doesn't one of these lawsuits even include some factor of her responsibility for not having a bouncer outside, given the frequency of drunk patrons coming out of a restaurant and getting into altercations?
So exactly. So the defendant, Ryan Joseph Haynes, in this case, who essentially did beat somebody up, as I understand it, right outside the restaurant. I'm still working on figuring out all of the details, but there was a declaration that he submitted, which La Poubelle then objected to. And in his declaration, he mentioned that if there had been a bouncer there, then he would have been much less likely to assault the plaintiff, Robert Browder, because there would have been someone there to break up the fight. La Poubelle objected to that, but it does appear, just based on skimming through the document, like it should have been an indication to that it would have been a good idea to get a bouncer long beforehand. Whereas Francois Custer, it seems that she's trying to act like, oh, there's never been any incident, and I needed to get this bouncer just because of the protesters. There's never been a need for anything like this before, when in fact one of the defendants in this case says, I wouldn't have assaulted that guy if there had been a bouncer.
So Zach, one of the reasons I was super interested when I heard about this is you have these restraining order hearings come up, and my understanding is that there's so much credibility is everything when it comes to these restraining order hearings, because it's basically he said, she said, he said, she said. And so what are your thoughts on if this comes before the judge and the judge is seeing Francois's declaration for these TROs, whatever, and she's like, we've never had any violence whatsoever. And then the judge sees not only has there been violence, but there's been lawsuits over it. And part of it's been has been about her lack of preventative measures to prevent such violence. How do you think all of this relates to each other in the TRO?
Sure. So there's a legal doctrine called the doctrine of clean hands, and it basically says you can't go to the court for relief if you yourself have dirty hands from the same thing you're trying to take remedy against. And if I don't know if any of the defendants have attorneys, have counsel representing them, but if they do, the obligation on their attorneys is to research all of those cases, just like Jacob has done. And you come in with a stack of paper. Judge, this stack contains every action in which La Poubelle has either been a plaintiff or a defendant. And so it is misleading at best and false, and the falsification of a document to the court at worst, to say that they come here having never committed wrongs of their own, and they have therefore violated the doctrine of clean hands. They can't come in here and say, well, people got in a fight because of the protesters, when in reality, I've got a stack of cases that says you have been derelict in failing to supervise and provide security at your place of business, comma, oh, and by the way, it's still illegal to overserve persons consuming alcohol, even if they're not going to drive. You have a legal obligation not to overserve or to allow someone who is an invitee, like a customer in your restaurant and bar, to become intoxicated to the point that fights break out.
Okay, then I have to ask your input on this. And I know you probably have to jump in a few minutes, and we're going to wrap up in a few minutes anyway. So you have the instance where I know the viewers probably don't know the specific instance that we're talking about, but two people come out of the bar. They're drunk. That's subjective. Let's say they're not drunk. They assault William Good. They destroy his phone. They break his nose. And then the bouncer lets the dude back into the bar. While he's in the bar, the police come. The police go in looking for him. They're told he's not in there. There's only one entrance and exit from that bar. That's the front door. So we knew he was still in there. The police come out. The police leave. And then the perpetrator is filmed on live stream running out of the restaurant to a waiting car and making his getaway. This all looks very, very bad for Francois and La Poubelle when it comes to a restraining order, much less, I don't know, maybe a lawsuit.
Yeah. So at the very least, the restaurant has committed obstruction of justice by not disclosing and identifying the existence of the individual who was involved in the altercation. Because the officers didn't just come in and walk around with their mouth shut, said, hey, we're looking for somebody involved in the fight. Anybody know anybody involved in the fight? And everybody at the restaurant said, oh, no, we don't know who you're talking about. Well, that's obstruction of justice by failing to provide material information to law enforcement who were conducting a lawful investigation. Now, law enforcement was also derelict in not securing the video footage and all these other things. And there's some other issues that go to the police department. There's certainly civil action possible against the police department for, dereliction and some other things, but also civil liability to the restaurant for, it's not just negligence, it becomes willful negligence, gross negligence, because you knew this person was involved in the physical altercation. Whether they'd been consuming alcohol or not, you knew they were involved in a tussle, or as a kerfuffle, as we say on my channel, and then you let them back into the restaurant knowing that they have an immediate past history of violence that you or people who are under your care as your employees, we call them agents, your agents knew or should have known that this guy was involved in a kerfuffle.
Right. Okay. Well, that's what we know for now. I actually, Jacob, I forget when the hearings for these TROs are. Do we know?
We do have the date. I have it written down somewhere. April 23rd is the date that I have in my head. I think that is right. I think it is April 23rd. I can confirm that once I get off of here, but I'm pretty sure that's what it is.
Okay.
So
we've got a little bit.
Mm-hmm.
Okay, good. So we've got a little bit.
I did indicate to DOA that I would be willing to be called as a witness if that's helpful on the last day that I was here in court. So I will plan to be here, and we'll see. We'll see what happens.
Okay, good. Great. Well, thank you guys for coming on here and doing this with me. I really appreciate it. You guys can find both Jacob and my lawyer friend Zach on YouTube. Jacob under Jacob Harkey, my lawyer friend under your lawyer friend Zach. All right, guys. Thanks for hanging out with us. Thanks to everyone who watches until the very end, and we'll talk to you soon.
Bye-bye.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not,